Hello all and welcome back for video 3.1.7 for the Legal Studies Guy. Our quote for today from Bobby Unser. Success is where preparation and opportunity meet. In terms of where we're all at this year, undertaking a Year 12 subject or undertaking our VCE certificate for a score, is each of us does have the opportunity. It's naturally built into the VCE that you have your exams at the end of the year, which obviously contribute about 50% in all of your subjects to your score. So that opportunity is there, and if you want success, you just need to add preparation. So hopefully that's starting now, nice and early in the year, and you're building those habits and hardwiring your brain to perform as well as you can at the end of the year and have that success. As the intro slide said, we are looking at 3.1.7 today. This is a new piece of content that wasn't included in the old study design. So if you are using notes from a past year or going through, you've bought notes off a past student, or you're looking at stuff that an old teacher's given you, this will be stuff that's not included, it's new. So 3.1.7 covers plea negotiations and sentence indications. Sentence indications undoubtedly will be a new concept, but plea negotiations might be something you've seen in shows like Law and Order before. So we'll have to unpack that a little bit, because the reality of them in Australia is quite different to what you may have seen happen before. We are going to cover off their purposes and their appropriateness. Our essential question that we are therefore going to answer is, what are plea negotiations and sentence indications, and when are they appropriate? So, basically why we cover these things off and what they're referred to is they're essentially tools that the prosecution has, or tools that are built in, I should say, to our criminal justice system to try and ensure that, or aim to achieve the idea that a trial will finish, that a case will not go to trial in the first place. Okay? They want to convince the accused person to plead guilty. Okay? This obviously saves a lot of money, because you don't have to impanel a jury, pay them, pay to have a prosecutor there, so on and so forth, judge running the trial, etc. But it also saves a lot of time, because you're not taking up court time with cases that perhaps are very much likely to succeed, and you should be or would be able to use court time for other purposes. So as I said, the two main tools that the prosecution has, the things that are built into our criminal justice system, are plea negotiations and sentence indications, and their purpose, which we'll get to in a moment, is essentially to try and resolve disputes without going to trial. Plea negotiations first up. Now I've got the image here of, the whole lamp on the table with the glass of water there, and you can imagine it shining the lamplight in an accused person's eyes, and so on and so forth. Plea negotiations, like I said, is something that you might have seen in American TV shows particularly Law and Order. And this is generally in shows like Law and Order, where the prosecution will go in and they'll say, hey, how about you plead guilty and we'll only get you 5 years in jail? Or how about you plead guilty and we'll cut it down from this charge to another one and make sure that you don't go to jail at all. Whilst the essential essence of what's going on in that situation is what plea negotiations are like in Australia, there are a couple, or in Victoria, there are a couple of distinctions that I'll unpack now. Plea negotiations are when the prosecution offers an incentive to the accused person in return for them pleading guilty. Okay? In the situation I just ran you through that you might see on Law and Order, the incentive for pleading guilty was, say, a cap on prison time. You will only go to prison for 5 years. In Victoria, that is not a deal that the prosecution can make. because judges are responsible for sentencing, and judges are independent. They're not influenced by the views of the prosecution or any deals the prosecution made. The judge is free to do what the judge wants. So an incentive for pleading guilty in negotiations cannot be a cap on jail time. It can be one of these two things. It can be a reduction in charge to a less serious offence. The most common one that perhaps springs to mind is, hey, if you plead guilty, we'll drop the murder charge and put it through as manslaughter instead. Naturally, that does attract a lesser prison sentence as a result, but the negotiation isn't centered around how long someone will go to prison for. The other incentive that can be offered is that some charges will be removed in return for a guilty plea for other charges. This is what might happen in instances where someone is charged with multiple offences. Prime example being, perhaps you've been charged with drug possession and also trafficking of drugs in some quantity. This is a very poorly hatched example. But the prosecution might say, you know what? If you just plead guilty to the possession charges, we'll drop the trafficking charges. Because a lot of trafficking or possession with intention to sell comes down to quantity. So they might say, hey, look, you've got this much quantity, we can charge you with possession with intention or intent to sell, but how about we drop that charge and you just plead guilty to these lesser ones? So it's the removal of some charges in return for a guilty plea on others. Sentence indications, on the other hand, and we have a picture here of the jolly judge, are a bit more specific in their or how they work. Sentence indications are where if you're charged with an indictable offence, at any point after that charge sheet is filed, you are able to ask the court whether, if you plead guilty, you would be sent to prison or not. So say you're charged with a serious assault, common assault, and you're due to go to trial in the the county court in September. It's January now. You can ask at any point after that charge is filed the judge, or for a judge in the county court, to look at the facts of the case and then tell you if you plead guilty to that assault charge, whether they would send you to prison or not. The idea being that people who are on these, say, borderline charges will ask if they'd be imprisoned or not, and if they find out that they wouldn't be imprisoned, then perhaps they're more likely to plead guilty, knowing that there's no risk of them going to jail, as opposed to defending themselves just to avoid that. It cannot be used as evidence at a trial if you request a sentence indication, okay? Because the assumption there is, or the insinuation is, if I check what will happen if I plead guilty, then maybe I am guilty, and it would be tough for you to feel confidence to do that if then at trial they could say, oh well, the evidence is pretty strong, but did you know that they asked for a sentence indication as well? Like, they asked what would happen if they pled guilty. Like, that means they were thinking about pleading guilty, which means they probably are guilty. Okay? So it can't be used as evidence at trial because that would create a bias or a prejudice against the person. If the judge, when they check over the details, says, no, I would not impose a sentence of imprisonment, and then the accused subsequently does plead guilty, they cannot be imprisoned. Okay? The judge can't turn around and back and say, actually, you know what, I didn't look at this properly, I'm going to send you to jail now. That's not allowed. As I stipulated at the top, the key thing we're after here is purposes. It says to us in the study design that we need to know the purposes. And the purposes of both sentence indications and plea negotiations is to promote a guilty plea, therefore resolving the dispute early. And as we know, that is about saving time, saving money, saving stress on victims, etc. Our skill here is a little bit different though. Up until this point, our skill has always been things like explain or describe. Okay? Things that fit on the lower level of Bloom's taxonomy that just require us to recall information and understanding. For the first time ever, we're stepping up. We're stepping up to discuss. And discuss is what we call an analyze style question. And anytime you're asked to discuss something in a exam question, it means that there are two possible sides to look at. So in this instance, we need to discuss and justify the appropriateness of the means used to determine a criminal case. Okay? Means used to determine a criminal case, meaning plea negotiations, and sentence indications. So this is the sort of question you might receive. Discuss, so we know when we discuss that this is exchange of opinions. Just imagine with a discuss question that you're having a class discussion where you're separated on either sides of the classroom and you have to exchange opinions about the matter. So this means that there are two sides that need to be looked at, and you're discussing the appropriateness of using plea negotiations, sentence indications to resolve a criminal dispute. And this is worth 5 marks. So in terms of the two sides to this, if we're looking at appropriateness, that means our two sides are that they are appropriate and that sometimes they are not appropriate. And here is the evidence we'd be looking to use. Appropriateness of plea negotiations. Plea negotiations are appropriate when there are going to be issues with the reliability, willingness to appear, and availability of crucial witnesses, particularly victims. This is common in examples of sexual assault, particularly more extreme examples such as rape, where victims are really unwilling to attend due to the trauma that facing their attacker is going to cause. And we know that they have some rights to provide evidence as a vulnerable witness. But in these situations, the prosecution will sometimes look to negotiate and try and get a guilty plea to avoid this situation occurring. To avoid getting to the day of trial and finding out that the victim doesn't want to appear anymore and the trial falls apart. So they'll try and use plea negotiations where there are issues with the willingness of crucial witnesses or issues with their reliability. They will also look to use plea negotiations when there are issues with the admissibility of key pieces of evidence, whether those pieces of evidence may be borderline prejudicial as opposed to probative. The prosecution will want to look to end the trial without getting in a situation where they're stuck debating crucial evidence in front of the judge. Or, this is a really, really common one. The prosecution will seek plea negotiations when the original charge by the police was incorrect. Whilst police do a very good job and they play a vitally important function in society, as we know, they're not, and they're trained in the law and they understand how the law works and stuff like that, but they're not lawyers, they're not legal professionals, they're not judges. Okay? And sometimes they can get in situations where they literally lay the wrong charge. Okay? Be that as extreme as laying a murder charge when in reality the situation is manslaughter. It's in these situations that prosecutors will go into negotiations and say, hey, you know what? The charge you've been charged with here, not ideal. Let's downgrade it and you plead guilty for us. And that will often lead to the early resolution of the dispute. When are they not appropriate though? So an exchange of opinions, as we said. Well, they're not appropriate in high-profile cases because there's a lack of transparency around the negotiations. It all happens behind closed doors and people get really upset about this. And you'll be able to look at a bit of evidence from the Herald Sun at the end of this to get some more information about that. They're also not appropriate where the victim doesn't wish for lesser charges to be considered. Okay? Because as we know, taking into account the views of victims in our criminal justice system is vitally important for it to retain its standing in the community. If the victim doesn't wish for lesser charges to be considered in negotiations, then really the prosecution shouldn't consider lesser charges. However, they do have no obligation to follow these wishes. What about sentence indications? When are they appropriate? Well, obviously, if we flick over to the not appropriate, they're not appropriate for offences where imprisonment is certain. Okay? This obviously kind of goes without saying. It's a logical conclusion that if you're charged with murder, if you're charged with a serious drug offence, you are going to prison. Therefore, a sentence indication isn't appropriate because you're just going to get told, yeah, if you plead guilty, you're still going to prison. They also might be considered not appropriate for some crimes against the person, such as sexual offences and assaults. Because sentence indications, like I said, you're going through the committal process in the magistrate's court and you ask for an indication. It gets sent off to a judge in the county court who'll just look over it and then kind of make a decision. So you're not on whether you'd go to prison or not. So you're not getting the full sentencing process, which we talk about a little bit later in this unit, that has a big emphasis on taking into account the views of the victim through victim impact statements. So therefore, sentence indications may not allow sufficient scope for a victim's views to be taken into account. It is worth noting, I didn't mention it earlier, that the prosecution has to approve a sentence indication. So in these instances here, the prosecution might say no, that you can't have a sentence indication. When is it appropriate though? Well, borderline cases. If it's not clear whether imprisonment would be the ultimate sentence or not, say for a common assault, it may be appropriate to allow the accused person to have a sentence indication, maybe find out they're not going to jail, and therefore make them more likely to plead guilty. Also, victimless crimes. Some drug offences, fraud, etc., where a victim's views do not need to be taken into account at sentencing, can mean sentence indications are appropriate because you are not trotting all over the victim. You're not pushing them to the side in sentencing. So if we go back to our question, and I will continue to reiterate this because it is so often done wrong on an exam, we need to discuss. So we need to have an exchange of opinions on the appropriateness of using plea negotiations / sentence indications to resolve a criminal dispute. Sample answer, how would you structure this? Well, the first thing to think about is how much evidence are you going to need? Okay? How many points are you going to need to make? And it's not as simple as, okay, there's 5 marks, I need to make 5 points, because then you're actually overdoing it. Okay? The key thing here is to look at the marks and use a rule that I call half plus 1. So this question is worth 5 marks. Half by 5 equals 2.5, plus 1 equals 3.5. So what I'm doing there is working out how many points I need to make as half plus 1. In this instance, it's 3.5. I'm probably just going to be happy for a 5-mark question, making 3 key points or having 3 pieces of evidence that I use. Therefore, we're going to look at structuring an answer like this. Okay? It's just discuss the appropriateness, exchange the opinions. It doesn't ask us to evaluate how good they are. It doesn't ask us to what extent do we think they're good. We just need to exchange the opinions. So we don't need to have a point of view or an argument in this. So it's as simple as this. We'd be looking at opening up with something like, plea negotiations are appropriate when, and then it's a simple process of identify, explain, extend. Plea negotiations are appropriate when there are issues with the availability of crucial witnesses, perhaps if we use this one. So identify that piece of evidence. Explain it. This makes plea negotiations appropriate because if a witness is unreliable or fails to attend, a conviction will not be recorded, whereas plea negotiations and a guilty plea ensure that one is. Okay? And then you extend, and perhaps to extend, you use an example. This may occur in sexual assault cases where a victim is unwilling to face the accused person or their attacker, and therefore the prosecution seeks plea negotiations to resolve the dispute without going to trial. So therefore you've identified when a plea negotiation is appropriate, you have explained it, and then you have extended it. You have extended yourself perhaps with the use of an example. What you'd then be looking to do is either say further and talk about they are also appropriate when, and then again you identify, explain, extend. Once you've done that, at this point we would have used 2 pieces of evidence. But you would note that they are both times when plea negotiations are appropriate. So in order to meet the needs of discussion, to exchange opinions, we would then add in our 3rd piece of evidence and we'd say, however. Plea negotiations are not appropriate when, and then again we identify, we explain, we extend. And perhaps our reason here is it's a high profile case and the public aren't going to be happy with us doing this behind closed doors perhaps. Okay. This is your structure for any longer response question. It's really important to use these linking words that make your answer flow together, and it's really important in your stems, okay, your opening sentences basically to each paragraph, that you use the terms from the question. Appropriateness, appropriate, appropriate, appropriate. Identify, explain, extend. Get that right, explain your content well and show understanding, that's a 5-mark answer. As always, we move on to our evaluating the ability of the criminal justice system to achieve the principles of justice. And I apologise for the sound of the washing machine that's been going off in the background for this entire video. Take a moment now to think about plea negotiations and sentence indications as we've talked about before and see where they fit into these 6 boxes. And we are going to, hopefully you've paused now, we are going to change the slide in 3, 2, 1. In terms of achieving fairness, both plea negotiations and sentence indications may lead to someone pleading guilty even if a conviction at trial is unlikely. This might be the instance where the person is guilty, they've definitely done the wrong thing, but because of the way the evidence works or the way the reliability of witnesses, etc., conviction at trial might be unlikely. If you can use plea negotiations to ensure a conviction, that's fair. What doesn't it achieve in terms of fairness? Well, the accused may make a decision to plead guilty without actually seeing the evidence against them, okay? Without actually going through the full committal process. And as a result, they may be almost tricked into, like if it's a situation where a conviction at trial is unlikely, once they see all the evidence, they should realise this and realise that, hey, it's my best, in my best interest to go to trial. Okay? So if they're making a decision without all of this at hand, that's perhaps a bit unfair. There's equality because everyone has access to them. And in terms of access, they can make the criminal justice process easier for victims, as I said, because victims avoid having to go to trial. However, it can be seen to limit access for victims in some circumstances, particularly with sentence indications, as their views are not taken into account as much as the usual sentencing process when a judge gives an indication. So there's just a little bit of a look at how that fits into the principles of justice. In terms of applying this information to actual or hypothetical scenarios, I recommend you look up this Herald Sun investigation here. Killer's jail time slashed with plea deals that leave victims betrayed. It's always very, very important to note that our current government in Victoria is a Labor government. As a general rule, the Herald Sun doesn't really get around Labor governments. So there's most of the Herald Sun's articles on law and order are very, very critical of the criminal justice system, and particularly the leniency shown towards offenders. So have that in mind as you read the article. If you're reading something from The Age, perhaps, there might be more of a focus on things like restorative justice and rehabilitation. This Herald Sun one very much on the idea that victims are betrayed because plea deals are, slashing jail time. So have a read of it with an idea of that lens in your head, that it's perhaps overly critical, and it doesn't look at the fact that, the amount of time that might have been saved through going through this process. Doesn't look at the fact that perhaps in some of these examples conviction was unlikely, and a plea negotiation was the only thing that got a guilty plea. So have a look at that one, really interesting. You can go to the Sentencing Advisory Council as well, and look up guilty pleas and sentencing, and you can get a bit of an indication of basically the sentencing process, the impact that guilty pleas have, and this will help you for some content later on. As always, to conclude, can you answer our essential question? Do you know what plea negotiations and sentence indications are? And do you know when they are appropriate? Have a crack at answering that. Leave reviews, ask questions if you need be, and happy studying.